don't get any other instructions, I will just start away, and Aikmini writes to me whenever we are ready, and we are ready. In case you heard us already before in our pre-meeting, indeed we have a bit longer time. You also probably saw already all the speakers. Still, I would like to open the panel 1 of the Eden conference with the title Show Us Your Face, We Tell You Who You Are, Facial Recognition Techniques in Criminal Investigations. And I'm very grateful and happy to have a distinguished list of speakers that I would like to very briefly present to you at the very beginning. So we have Peter Fussey, who is professor at the University of Essex with us. We have Gloria González Fuster, research professor at the Vrije Universiteit, Brussels. Co-director of the Law, Science, Technology and Society Research Group, and member of the Brussels Privacy Hub. And we have Brian Honan, who is from BHConsulting, and Xavier Tracol from the Eurojust Data Protection Office. I'm getting another message. Are we live now or not? Jan, can you please enlighten me?
I think we are. So there are a lot of messages which has to do with a 30 minutes gap. So I think we were live earlier than we expected, but I also understand we are still live. So I would suggest we just go ahead.
Sorry, Jan, I get a message that said we are not live from Michael at this point in time. So I really need from Michael now a message whether we have to restart or whether the participants heard us already.
Live, I see in the moderator chat here. So let's go for it, guys.
Good. So after having introduced the speakers to you, I think the topic that we have to discuss here is indeed something that is related to the interesting times we are living in, that are influenced by sometimes breathtaking technological developments. So artificial intelligence was already the buzzword in January in the CPDP conference, and it still is. This often frames the debate mainly focused on big data in previous years. The rise of artificial intelligence technologies requires a new dialogue. Sorry, I'm in my office. And sometimes persons still want to call me. The artificial intelligence is, as we know, is the new buzzword, framing a debate mainly focused on big data in previous years. In order to address the challenges that are related to artificial intelligence, there is the cooperation needed across different sectors and among different stakeholders. And this is, in our opinion, essential. In particular, law enforcement needs to be prepared to combat criminal abuse of such technologies, ultimately making cyberspace a safer place for all. Many of the underlying issues are interlinked and affect not only law enforcement, but go well beyond. In this panel, we would like to concentrate and focus on the area of law enforcement. The face recognition technology or the use of the face recognition technology by law enforcement is sometimes regarded as non-compliant with the principles of democratic society. Actually, the EDPS in his welcome note mentioned that he called for a moratorium on the development of face recognition technology. And therefore, the technology as such raises unprecedented issues from an ethical and societal point of view. If you have the time, please visit the artist booth of Martin Stick, who has a very interesting artwork in relation to face recognition, where you can see all the details of the possibility of this face recognition technologies from an artistic point of view. The increased use of the biometric data, along with the impossibility to change our physiological traits has also greatly increased our concern on biometric data security. If biometric system designers do not implement appropriate safeguards, the consequence of a personal data breach would be very serious. As proposed by the EDPS himself in his welcome speech, I also believe that in order to use biometric data processing and to let this area thrive, it is vital to invest in public trust in this particular sensitive area. And I'm very happy to have distinguished speakers with diverse experience and also expertise that will look during this panel into legal information security as well as practical aspects of the use of face recognition technology. And I'm happy to give as the first speaker on this panel the word to Professor Peter Fussey. Please take the mic and provide us with your contribution to this panel. Thank you.
Hello there, can you hear me okay? Okay, thank you very much, Daniel, and particular thanks to Jan for inviting me. You know, as an academic, it's always a pleasure to engage with the practitioner community in particular. So thank you for that. I'm speaking from London today, and many of the things I will talk about will have a UK-centric focus, but I'll try and sort of widen those out as I go through. So I've been given the brief of talking for about 8 minutes. I've been researching facial recognition for more than 10 years, police uses of surveillance for more than 20, so I'll do my best. Just as a couple of introductory points, my background is that I led the independent review of the Metropolitan Police trials of facial recognition during 2018, 2019. So I've got some insights from the operational sort of aspects of that. I also contributed an amicus to an amicus curiae brief to the Bridges appeal, Court of Appeal this summer, and have also just worked with on national guidance for the regulation of facial recognition in England and Wales. So I'll try and sort of bring some of that experience into what I say. Two very quick points, I think, as I'm the first speaker on facial recognition that I should mention. I think, first of all, it's important to think of facial recognition surveillance as fundamentally different from other forms of surveillance. It's often equated to things like CCTV cameras and so on. It's fundamentally different and requires a different regulatory vocabulary to understand its impact and how it can be mitigated. Secondly, when we talk about facial recognition, we're talking about lots of different technologies at play. There are fundamental differences between one-to-one verification, where we're unlocking an iPhone, to, you know, police surveillance of, say, you know, the Notting Hill Carnival in London, for example. And also there's a collection of very different practices that make facial recognition happen, that we should get into. Okay, I've got 5 quick reflections I want to talk about from my experience and work in this area. There's more to say, of course, but I'll leave it at 5 for now. The first is about authorization, regulation, and oversight. You know, often when facial recognition technology is debated in public, often a lot of the political and public language is around its legitimate aim. That police can use advanced surveillance technologies to keep the public safe is, you know, beyond debate. It's beyond question. There's a legitimate aim for that. Then the questions, certainly from a human rights perspective, become, well, what's the legal basis for this, and whether they are necessary in a democratic society to use this measure. Taking those in order of how they appear. The legal basis, there is no, certainly in my country, there is no legislation that explicitly authorises police use of live facial recognition. There may be an implicit authorisation, but there's no explicit, and that's been proven in the court during the summer. On necessity, it's really interesting how often when, you know, planning meetings and deployment meetings, when people talk about necessity, they often talk about whether it's necessary to use this technology for what they're trying to achieve, but actually the formulation of necessity is whether it's necessary in a democratic society, and the various conditions for that, where it has to be used for a particular aim, but it also has to be rationally connected to the purpose for which you are using it for. And I think one of the key things really in the legal sort of challenges around facial recognition for time over the last year or so in my country has been criticism of the very speculative uses of facial recognition in case someone might happen to walk past somewhere without having any kind of intelligence whether they would or not, and also the drifting justifications, of which I can talk about at length, when it's used for one purpose and then other justifications are inbuilt into it. The second point I think that's useful to frame the debate is about which rights are at stake. Often we talk about privacy, which of course is important, but it's insufficient to capture the range of harms and issues that are imposed by facial recognition. Many different rights are engaged through the use of facial recognition. That affect individuals at a very individual level about the development of their identity, but also more broadly at the healthy functioning of democratic society. So we can talk to rights of freedom of expression, of assembly and association, for example, bringing the chilling effects. And this all happens before we even get into issues of discrimination and sort of legitimacy that come from that as well, which, I think are really, really important to get into in this discussion. Okay, so the other point here, I think, on rights is it's not just the rights of the person who is on the watch list or the rights of the person who is matched. It is the rights of everybody who passes by the camera that is at stake, and that's been upheld in the courts in England and Wales as well. Number 3, performance. The history of technological solutions for policing is littered with hubris and overinflated claims of effectiveness, and facial recognition fits squarely in that tradition. I've heard absolutely ludicrous claims about its effectiveness, and I've spent days and days and days in police vans and seen what happens in reality. So we have to have an honest discussion about that. Also, I think more problematic than technological limitations are the way in which statistics and science, in quotations, is used to make claims that don't stand up to scrutiny. And I can talk at length about that as well. I think it's not only an issue here is not only about the system performance of these cameras, but also about the human element as well, and human adjudication, which is my 4th point. So we all know about the law enforcement directive, or, sadly we have Brexit in my country, which means that there might be some divergence, but in the law in the UK, we have a similar provision in the Data Protection Act about human intervention in automatic processing or automatic processes, for instance. So it is not a question, or it is not in question, whether there is any human decision making in facial recognition processes. That absolutely exists. For me, for someone who studied this as a social scientist, I think the real question is, what is the quality of that decision making, and what is the quality of that scrutiny? In the research myself and my colleague Darren Murray did, we saw a clear presumption to believe the algorithm, to believe the facial recognition system, even though the actual algorithm was incorrect most of the time. So there's a real question about the quality of decision making, and whether that decision making can be audited and held up to scrutiny, as other forms of police decision making are. And then the final point, there's lots more to say, but the point I want to finish on is about, watch lists, the database that underpins facial recognition. This is, the backbone of facial recognition systems. And as in the Bridges Court of Appeal case in the summer, was shown to be a site where excessive discretion takes place. And I can talk at length about this. It actually took me days and days and hours of interviews to untangle how watch lists are populated in London. And there are several questions here that are really important about who becomes enrolled on watch lists, why, where the information is drawn from, what kind of oversight exists, and whether these decisions are auditable or not. There's more to say. I haven't got into issues of bias or around public-private systems and things like that as well, but I think that's pretty much my my time is up, so I'll hand back to Daniel.
Thank you very much for this contribution, Peter. We really appreciate this. And the good thing is also that everybody could hear you, while before you spoke, it seems to be that Jan and I were on the screen out of a previous recording. Our apologies for this, but Peter, your contribution was fully seen by the participants, and I'm very happy about this. I would like now to turn to Gloria as our next speaker. Gloria, may I ask you to come in and provide your view on the topic that we discussed today? Thank you.
I'm here. I hope you see me. You hear me. Somebody sees me somewhere. Thank you very much for welcoming me here. I'm talking from Brussels. And I'm talking from indeed a different perspective, more like the legal perspective, and really also the Brussels perspective. I'm concerned with European fundamental rights and also European debates about facial recognition. We already heard that the EDPS is calling for a moratorium. More people are calling for a moratorium. What does it mean? A moratorium is just basically time. They're calling for time to do what? They don't always specify this. To do what? I think it's basically for us, the legislator, to think about whether we need some new rules or we can go ahead with the developments that we have. I think the introduction, the first presentation was very useful to situate facial recognition. I hope we can agree that when we think about this subject, there are three basic starting points that are generally not discussed. I think the first one is that facial recognition is happening. It is here. You are an advanced community, you know that facial recognition is being used, at least in some cases. So it is happening already. The second basic point is that it potentially seriously interferes with many of our fundamental rights, not just one, but many, and this was mentioned also before. And the third point that I think we can easily agree is that it interferes with the fundamental rights of many people, of a large number of people, persons of the general public, members of the general public, many people. So it seriously interferes potentially with the rights, with many rights of many people, and it is happening now. And we are, people are calling for time to think, but I think we ask for time to think. At the same time, we have to think quickly, because we need to do something, because it is really happening now. So in my minutes, I will indeed just try to open up this question a bit more. Do we need more rules? Yes, no. How do we assess this? I think that normally the scientific way to deal with this is first to try to figure out which rules do we have and whether those rules that we have are fit for purpose. And I think we can agree that at the European Union level, the main rules that we have in practice, even if many fundamental rights are interfered with, the rules that we have are basically data protection law rules. These are the main device that we have to do something about facial recognition. And I'm very happy, as I said, to be here with you and to be saying this to you, because I know that you like data protection law, that you like discussing data protection law. I think it's in the title somewhere of the conference, on the program, it says data protection law, it's at the heart of all these discussions that we are going to have today. I heard the executive director saying that data protection law is in the DNA of Europol. It is not even in my DNA, but it's in the DNA of Europol. So it's great that you like to discuss data protection law. And the executive director also said that it's not easy to discuss data protection law in the context of law enforcement. My experience is that it's not easy to discuss this anywhere at all. And even not when discussing facial recognition in other circles. So I often or sometimes discuss also with other type of people and also with people who are actually very extremely concerned with facial recognition and very reluctant to accept facial recognition. And I seem to agree with them somehow. And then at some point I mentioned data protection law and they look at me like, oh, why don't mention privacy, data protection law, as if this was a threat to this broad notion of there are many issues there. They think that by mentioning data protection law, I'm trying to narrow down the discussion. And really, I'm not trying to do this. I hope you can see this. And I hope you can, in the future, also help me translate this to people, that it's not because we are discussing data protection law that we are not aware that there are many fundamental rights that are at stake, and that perhaps those data protection rules can help us do something positive for the other fundamental rights. So basically, what I have done now is to rephrase my basic question: do we need new rules? It means we have to ask which rules do we have, and this means assessing how are those data protection rules that we have fit for purpose. Are they fit for purpose, yes or no, in light of facial recognition as it is happening? And I suggest that actually we divide this question into 3 questions that I think I can at least mention. And these 3 questions are: first, are the rules that we have on data protection law as such cover all the developments that are happening? And I would say in short that no. And what I want to say is that actually we know that from a data protection law perspective, when we think about facial recognition, we think very much about this question of this is biometrics processing of data. This is about biometrics in the sense of Article 414, biometrics for the purpose of identifying somebody. And we know that this is extremely serious, and it can generate a lot of problems. So we focus very much on this. But I think that when we look at the reality, the ways in which technologies surrounding facial recognition are occurring, in many cases, you cannot really trace all the risks related to fundamental rights to this very specific processing of data, of biometric data in that very specific sense. And for me, if we fail to do this, to see that the problems are sometimes also when there is no processing of biometrics in that specific sense, we are missing part of the problem. And in that case, we really make it easy for others to tell us we are narrowing down the problem to something. I'm referring here, for instance, to something that was an approach that is supported by the European Data Protection Board in their guidance on video devices. They say, well, when you have a camera that very briefly processes biometrics in the sense of biometrics, this template of facial recognition, it is extremely problematic, even if they just do this for a millisecond and then they delete it, extremely problematic processing of sensitive data. But if you have a smart camera just classifying people on the basis of their gender, on the basis of their age, automated classification of people, but no use of biometrics, everything is fine. It's not that serious. I think that we are missing something there. It is, for me, serious that we have machines that automatically classify people on the basis of their age and their gender. People and machines are regularly misclassifying me on my age, on my gender, on many things. So I would not trust machines that do these kind of things very often together with facial recognition, but in a way that law is struggling to frame correctly. Second question that I want to share with you is, do the rules, the data protection rules that we have, which might be fit for purpose, are they especially fit for purpose when the processing that is at stake relates to law enforcement? And here, short answer, no. I don't think they are. We know that there are many special rules that apply for law enforcement, basically 2 types of rules. One of the basic ideas of data protection is that we limit the possibilities to process data when the purpose of the processing is law enforcement related. You know, you have this joker card. Maybe I couldn't process this data, but law enforcement, I can process this data. One possibility. We know that when data are processed, you have to respect some rights of the data subject, but a second joker card, it's law enforcement. Perhaps we can restrict here the rights of the data subject. I think that's the choice of the legislator. It is probably a good idea that we give these joker cards to the police, but we only give you these joker cards on certain conditions, and especially when using novel technologies that are controversial, like facial recognition, the use of these exceptional possibilities has to be accompanied by specific safeguards. And I think we are now at the stage where we're missing those specific safeguards, the safeguards that regulate the algorithms that can be used. And we know these algorithms can be biased, can be very problematic. And some rules that maybe have to regulate you, the law enforcement community, and you, the private companies working with the law enforcement community. So that was the second question. And the third and final question is, do the rules that we have that are perhaps fit for purpose, are they actually respected and are they actually enforced? And the short answer is, I think they are not. I don't know that much about reality anymore because I don't really leave my house anymore. But I go, for instance, to the supermarket, but we are still allowed to go to the supermarket. Is my supermarket using facial recognition? I don't know. I have the feeling that sometimes in the self-scan, yes. I did an access request because I have this great right to data protection that I can do an access request. And they replied to me 23 days after my request saying that on average, we delete our data 19 days after, so there is no data that we can give you. So thank you for asking, but we cannot tell you anything more. We know that it seems that the airport and the supermarket are the places where this facial recognition is now spreading. Data protection authorities are doing some work about this. We know that data protection authorities are not don't have a lot of resources. They have a lot of work to do. Luckily, despite the fact that they have a lot of work to do, they have some free time to read the newspaper, and then reading the newspaper, they realize that actually, in some cases, at the airport of their city, there is some facial recognition initiative, or they discover that indeed in a supermarket there is some facial recognition initiative, and they do something about this. More seriously, actually, we know they are investigating the case of Clearview AI. They are doing things. I wonder if they are quick enough, if who is going to win the advent of facial recognition. DPA is trying to do something, or us thinking about this or calling for a moratorium to have time to think about this. So I think I'm probably out of time, and I will stop here. Yes, and I'm happy to continue the discussion afterwards. Should I mute myself, or do I get muted?
Yeah, I think Gloria, if you can mute yourself, then I would take over from here. Thank you very much, Gloria, for your observations that you shared with us, and also for asking questions actually, or put this at the debate of the panel. I very much liked your notion about giving jokers to law enforcement authorities, but these jokers have to come with a specific and tailor-made safeguards when it comes to data protection. I think that is surely an idea we can further develop in this panel. You also mentioned that the data protection authorities are started investigations in this area of Clearview, where certainly we will also later on still talk about this. And your very first question was actually whether the existing data protection frameworks are fit for purpose, and then you added some specific questions to this. And from my point of view, this is indeed something we should look at, especially, as I said at the beginning, we have a vast technological development here. And indeed also frameworks sometimes have to be adjusted according to the new challenges that are actually there. To talk about Europol, you know that the Europol regulation is from 2017. We have 2020, and there is already a recast of the Europol regulation in the process, and this addresses mainly technological developments when it comes to big data. Of course, a lot of other points as well. But I think that shows that also from the Europol side, there's very much looked at, is the framework that Europol operates actually fit for purpose when we look at the vast technological developments, also, of course, in the area of face recognition technology. Talking about technology, I would like to turn to our next speaker, which is Brian Honan, representing his own company, the BHConsulting from Ireland. I'm very happy, Brian, to have you with us. I indeed miss our interventions in Maastricht at the European Institute for Public Administration in the past. But I'm grateful that you accepted this invitation and share with you. I guess as you are an information security expert, a view more in relation to the technical side of face recognition technology. Brian, please grab the mic. The floor is yours.
And thank you, Daniel, and thank you, Europol and Eden, for inviting me to be on this panel. I'm actually, it's one of the few panels I'm excited to be on, because when I look at my colleagues, I can see I'm going to learn a lot from this panel. Not just participate. I'm going to learn, which to me is a big plus. So I just want to talk through a few concerns I have and regards facial recognition, facial technology, and I suppose tongue-in-cheek, seen as the title is about the use of facial recognition with law enforcement. There are some crime fighters I think we're all familiar with that aren't very big fans of facial technology. Batman, for example, always goes around and working when he's got his mask on. We're all familiar with Spider-Man, another crime fighter who is very worried about facial recognition and people recognizing him. Superman, probably the most famous of all superheroes. Now, his take on tackling facial recognition is unique amongst these crime fighters, in that the other ones wear masks, and Superman just puts on a suit and a pair of glasses to fool facial recognition. So I think maybe that's a very apt point to bring in some of the concerns that have already been expressed by Peter and Gloria regarding the reliability of the technology being used. And while we're on the theme of superheroes and stuff, this is a very famous quote from Uncle Peter, Uncle Tom, which is Spider-Man's uncle. Just before he died, he turns around to Spider-Man and he goes, "With great power comes great responsibility." And I think that's a key message we need to keep in mind when we're talking about facial recognition and facial technology. Because while it is in place, any of us using a modern mobile phone or even modern computers, we're maybe using facial recognition to unlock your phone or unlock your computer. So it is in place. But the technology itself and how we use it, I think there are quite a number of gaps that we need to be aware of, and we need to be very cognizant of those and take a very cautious approach to doing things. As a technologist, I love technology. My family's always given out to me because I'm constantly buying the latest gadgets and playing with them, etc. But that doesn't mean just because something is new and cool that we should all rush out and deploy it everywhere we have it. Because I firmly believe facial recognition technology is still relatively immature, and there are also many ethical and privacy issues that we still have to resolve, and there are much more learned colleagues on this panel than me to go through those legal and ethical issues as well. And I think even just to highlight the immaturity in this industry, we have discussed already the moratorium on facial technology, but also some of the firms doing research in these areas have halted their research. IBM have halted their research in this area due to concerns of the ethics of the technology, and Amazon, using its police facial recognition project, Recognition, has put their project on hold for a year while they review the situation. And there are concerns over how accurate and unbiased this technology is. Many of the technology solutions that are being deployed in this area have been developed by companies in the Western world. And with all due respect to the people developing this technology, they're predominantly white, and if they're white, they're also predominantly male. So this leads to concerns over inherent and unconscious bias that they may introduce into this technology. And we're seeing this bias, by the way, in other technology as well, and how other technologies work. It's not just in facial recognition, but it's an issue that we have throughout many other technology platforms, etc. Also, these facial recognition platforms These are being trained by the images that are being fed into them so that the artificial intelligence can identify and construct the frameworks around the faces, etc. But very often, the images that are being fed into these technologies and these AI engines are the images that reflect the society, the software companies are developing the software in. So we end up with a system that is learning based on what is the most prominent, its most dominant profile in the system, which tends to be white males. And so as such, many facial recognition systems have been found to misidentify people from various backgrounds to various degrees. I saw research there while I was reviewing information for this panel that a review of 3 commercial systems found that they had error rates of 34% for dark-skinned females, which is an error rate actually of 49 times higher than that of for white males. And in particular, they found that women from Native American background were found to be ones that were misidentified by these facial recognition systems the most. And indeed, I mentioned the Amazon recognition system earlier on. It misidentified Oprah Winfrey as a male. So I think there's examples there of how this technology is still not mature for maybe widespread use just yet. As I said, there are people more qualified than me to discuss the privacy issues, but from my point of view, as a citizen, I want to know how is my privacy protected from these systems while I'm out in public. You know, these systems automatically process my sensitive data without my consent, or even in some cases without my knowledge. Gloria's example there of where she went into her local supermarket and wasn't able to get any transparency on whether or not the systems they had in there have facial recognition. So where is my option to opt out? Is it going to be a case in the future that if I want to opt out of these systems, I'm going to have to stop going to public places? And where are the protections for my privacy and human rights? And from a cybersecurity point of view, my concern would be over the protections that there may be around these databases, both the databases of people to look at and maybe these watch lists. How secure are they going to be? We've got a fantastic example this week of how cybersecurity is not 100% with the SolarWinds Sunburst breach, which has led to significant breaches in many U.S. government departments, and indeed that breach may be bigger and be more widespread than outside the U.S. So, you know, if somebody could get into those systems and change people's facial recognition aspects, it could either hide real criminals or put innocent people away. So I have concerns from a cybersecurity point of view on the protections around that area as well. And there the error rates of the systems, as I said, is a concern, and also it's privacy. With all due respect to our US colleagues, Schrems 2 has identified that the US is not known as a bastion for protecting the rights of the privacy rights of the individuals. But within the US, 11 cities have already banned the use of facial recognition technology. The Detroit police have also admitted the technology they use has an error rate of 94%. Now, I will bow to Peter's better knowledge and insight into whether that error rate they've admitted to is accurate or not. But the key question I have is that if I'm misidentified by facial recognition systems and I'm arrested as a suspect by the police, what is the impact on that to me as an individual? What's the impact to me in my life, my career, my business, my family, my social standing in my neighborhood, even when I'm subsequently released as an innocent man? There is the saying, there's no smoke without fire. So, this could have a significant impact on individuals. Now, as a fan of technology, I do see facial recognition having a place and a need, whether it's used to the standalone system that is scanning photographs and comparing against photographs, maybe, or as opposed to being used in widespread public use, scanning crowds as they go backwards and forwards. But I firmly believe we need to better understand its capabilities, but more important, its limitations before deploying it in the real world. And we need proper legislation and regulations to ensure our human and privacy rights are respected and not abused. As I said, I use facial recognition to protect my own phone because the only one impacted by that technology, if it goes wrong, is me. It just means that the system misidentifies me. It only impacts me. I can't get into my phone unless I use some of the other methods I can get in, like my PIN number, etc. But do I have confidence in facial recognition technology today in its use in criminal investigations that won't falsely identify me as a suspect and the subsequent impact on my life? No, I don't. So I'm looking forward to our panel discussion. Again, thank you for inviting me here, and thank you for listening to me so far. Thanks, Daniel.
Thanks so much, Brian, for your overview that you gave regarding the technical development. I personally would be very interested if you can tell us more about the Amazon police project that you mentioned that has been put on hold, as I understood, also a kind of moratorium to stop development in this area. You outlined the criticality of the error rate and the sensitivity of the systems in this regard. I would really wonder how this will work now with masks. What have masks actually for an impact? What I read is that there is also a vast technological development to bridge this gap. Your last slide was mind the gap. So I understood that they bridge this gap technologically in order also to get this right and to get better percentages in this regard. And in particular, thank you very much for your last remarks when you actually put yourself in the shoes of a citizen that might be impacted by face recognition and the work of police. I'm sure that we will talk later also about the point you mentioned about cybersecurity and if these watch lists exist, how sensitive they are and how well protected they must be. We will probably have the possibility to come back to this. For the participants, I see already questions coming into the chat function. Please keep on asking your questions, which we will visit actually after the next speaker that we have. And the next speaker is Xavier Tracol from Eurojust, working there in the data protection office. It would be actually just 150 meters away from the Europol building here in The Hague. But Xavier, I don't know if you're in your office, but I'm sure that you are in The Hague. Xavier, please, the floor is yours.
Thank you very much, Daniel. I'm actually talking to you from home, which is in The Hague, which is not very far away from the Eurojust building, and therefore not very far away from the Europol building either. I think that regarding facial recognition, it's very interesting to compare the situation in the US and the situation in Europe. The situation in the US is that there is no United States federal law which does currently regulate the use and retention of facial recognition technologies. So that means that there are currently no federal guidelines to limit or standardize the use of facial recognition and to require transparency for government use of facial recognition technology. I think we're interrupted. I think we've been interrupted. I don't know whether you've just heard what I said, but I was basically saying that there is no currently any applicable federal law in the US on the use and retention of facial recognition technologies. However, at the state level, there are a few rules which are in force. For instance, in October 2019, California passed Assembly Bill 1215, which is a 3-year moratorium on law enforcement agencies from using handheld and body-worn cameras for facial recognition. So this AB 1215 prohibits an automated or semi-automated process which analyzes biometric data in connection with data collected by an officer camera. Now, this law in California was adopted because, as Brian pointed out before, there are some cities in the US, including in California, which also adopted a ban on facial recognition technologies. San Francisco was the first of them to prohibit its municipal agencies from using facial recognition technology. And afterwards, Oakland, also in California, followed suit on the 16th of July 2019. And the recital of the ordinance, which was adopted by the City Council, is quite interesting, because I quote, it says the following: face recognition technology runs the risk of making Auckland City residents less safe, as the misidentification of individuals could lead to the misuse of force, incarceration, and minority-based persecution, end of quote. So as you can see, very strong words of the City Council of Oakland. And Berkeley in California also adopted a similar ordinance on the 16th of October 2019. So you see three Californian cities, which led to the law which was adopted at the state level in California. But again, the situation in the US is that at the federal level, there is still nothing, which is very problematic. The examples that I provided regarding the cities is a mere example. There are many other cities, especially in Massachusetts, which adopted similar ordinances. Now, that led also this situation of having no federal law which applies to facial recognition in the US led to the reaction of the industry, and several speakers have already mentioned that, so I will not dwell too much about it. The DPS referred to Microsoft. Brian also referred to IBM and Amazon. When it comes to Amazon, and that's a bit in reply to the point made by Daniel, we're talking about the recognition software, recognition with a K, not with a C, so which was put on hold for use by law enforcement by Amazon. Now, what is important to be emphasized in my view is that regarding the scope of all the statements made by the industry, these decisions from IBM, Amazon, and Microsoft apply to the American context only. And of course, we should not be naive. There is an aspect of public relations. All these statements were made in the context of the Black Lives Matter movement. What I would point out as well is that, in my view, the private sector should not set the tone of the debate on regulation of facial recognition, since there is social dimension to this debate, so it should not be taken over by the industry only. So that's all I will say about the US. So again, it's very interesting to compare this situation in the US, where again there is no federal law which applies to facial recognition technology, to the situation in Europe. And here in Europe, I believe that we need to clearly distinguish what is going on at the level of the EU and at the level of member states. Now, first regarding the EU, facial recognition implies the processing of biometric data within the meaning of the law enforcement directive. It is therefore sensitive data. Article 10 of the Law Enforcement Directive on the processing of sensitive data provides that the processing of biometric data for the purpose of uniquely identifying a natural person must be allowed only where strictly necessary, subject to appropriate safeguards for the rights and freedoms of the data subject, and only first where authorized by union or member state law, second to protect the vital interest of the data subject or of another natural person, or third, where such processing relates to data which are manifestly made public by the data subjects. So as you can see, there are three very strict alternative requirements. And in addition, any interference with fundamental rights must be strictly necessary under Article 52 of the Charter of Fundamental Rights, and data controllers must be able to show it. Last, facial recognition involves processing a large amount of personal data and affects a larger number of data subjects. So it may cause a high level of risk to the rights and freedom of natural persons of varying likelihood and severity. That means that the controller must carry out an impact assessment of the processing operation on the protection of personal data in accordance with Article 27 of the Law Enforcement Directive. Now, on the 30th of June, the EDPS released a position calling for a temporary ban on automated recognition technologies, which capture biometric data, including faces, in public spaces. On the 2nd of July, the Libe Committee, so of the European Parliament, followed the EDPS and backed a moratorium on facial recognition for law enforcement purposes. A report of the Libe Committee warned that the risk linked to AI technologies are aggravated in law enforcement, as they might undermine the presumption of innocence, liberty, security, effective remedy, or fair trial of individuals. On the 3rd of September this year, the Commission stated that it was considering a potential ban on the use of facial recognition technologies in public spaces in the EU. The Commission also stated that it would look into whether we need additional safeguards or whether we need to go further and not to allow facial recognition in certain cases, certain areas, or even temporarily. And regarding live facial recognition, the EDPS stated that he supported the idea of a moratorium on automated facial recognition of faces in public spaces on the 7th of October. Now, I understand that I'm running out of time, so I will move on. Again, this situation at the level of the EU should be contrasted within Europe with the situation in member states where police forces have already been using facial recognition technologies all across Europe for a few years. And for instance, I refer to Germany, Austria, Italy, Sweden, Belgium, and the Netherlands. The problem is that law enforcement authorities are not always open or fully transparent about their use, and this lack of openness and transparency negatively impacts on the scrutiny which is exercised by the Commission, since the Commission is in charge of monitoring the enactment of the Law Enforcement Directive, including Article 10 on processing of biometric data, which sets out the 3 very strict requirements that which were mentioned earlier. And in addition, this lack of transparency leads to a lack of accountability. This situation raises concerns about the respect for private life and risk of discrimination. In November last year, a paper of the fundamental rights agencies of the EU analyzed the implication of relying on live facial recognition technology. It focused on its use for law enforcement and border management purposes. The Fundamental Rights Agency emphasized that a clear and detailed legal framework must regulate the use of facial recognition technologies, determining when the processing of facial images is necessary and proportionate. Now, I had planned to get into a lot more details about the landmark judgment rendered by the UK Court of Appeal on the 11th of August. I understand that I don't have time to do so I will simply move to the following point that I would like to make, which is that from a legal perspective, facial recognition is the Wild Wild West. And there are 2 options in my view. The first one is to prohibit its use entirely, as it was done in many American cities. So in the US, in my view, what is necessary would be a very strict federal law, which is missing on the respect for privacy. The adoption of this federal law should also assist after the invalidation of the Commission decision on the Privacy Shield by the Grand Chamber of the European Court of Justice in the Schrems II judgment. The second option, if beyond the mere ban of facial recognition, is to have a specific EU regulation on facial recognition. And hopefully the US federal law and the EU regulation should be consistent. Now, of course, this is only half of the question, since it's all very well to say we need an EU regulation on facial recognition, but what about the content of this regulation? And here again, I believe that the paper or the fundamental rights agencies of the EU is extremely useful. Since if you look at this the content of this paper, it refers to purpose, to the impact on behavior, the place of use, the margin of error, public procurement, monitoring, and the impact assessment. I think that the impact assessment is really the key here. And last, I would like to refer on this point of the impact assessment, draw your attention to General Recommendation number 36, which was adopted by the United Nations Committee on the Elimination of Racial Discrimination on preventing and combating racial profiling by law enforcement officials. That's a very recent recommendation adopted on the 24th of November this year. Paragraph 59 mentioned that states should carefully assess the human rights impact prior to employing facial recognition technology that can lead to misidentification owing to a lack of representation in data collection. So again, there are many calls for impact assessment from various angles, including the human rights angle. Again, I think this is really the key and should be a key element, therefore, of this EU regulation on facial recognition that I'm calling for. Thank you for your attention.
Thank you so much, Xavier, for your view on this and also putting the US situation in perspective with the EU situation. I think that was very, very helpful, this overview. Of course, time is always too little to go in all the depth of the matters. We got some interesting questions in our participants' questions chat. I would like only to pick on two questions that arrived, and the first one is directed actually to Gloria and also to Peter, and it is about the right to be presumed innocent and the question of face recognition technology application by law enforcement. So if I can ask you, Peter, and then directly afterwards, Gloria, to very briefly to pick on that, and then I have another question afterwards for Brian and also Xavier, and that came in particular in relation to the US situation where Susanna actually asked in the chat that it was recognized that the uneven approach of US federal states and cities on facial recognition led to security loopholes because criminals are hiding in such stage, which is not good for public security, obviously. Maybe very brief, your thoughts on this statement, which is not really a question, but it is a statement, but I would be interested. But first, please, Peter, if you want to come in, and then directly afterwards, Gloria, please.
Thank you very much, Daniel. I think I'll be brief, and I think Gloria's sort of more legally focused response might be more useful than mine, but I do have a couple of responses to that question about the presumption of innocence. I think there's four things that I think are important. Firstly, I think something that's really important to always foreground in discussions of facial recognition is that it's not just about the person on the watch list or the person that's matched. It's about everybody who passes by the camera. And, that was upheld in the original sort of judicial review of facial recognition in England and Wales. So it's a wider sense. Then when we start thinking about the presumption of innocence, then that becomes more complex. And that leads to the second point, really, that facial recognition operates differently than other forms of surveillance, such as covert, surveillance and more sort of traditional forms of surveillance, because it kind of subverts the sequence of surveillance. You sort of have everyone passing the cameras and being put under surveillance before being sort of targeted, whereas it's kind of the other way around with a lot of forms of surveillance. You have a reasonable suspicion and then enact the surveillance afterwards. And why that's important, or why those two things are important, is because of the impacts around things like chilling effects, which are documented, and we're short on time, but if we had longer, I could talk at length about the evidence for that. So you are naturally affecting the rights of individuals by putting these by putting facial recognition in place, by deploying it. I think the other point that's really important is to think through. So chilling effects was the third one, and then the fourth one is about watch lists, really, as well. It's not just about how the technology works, but looking at actual live use cases, we can see the construction of watch lists is really varied in terms of the practice. There's way too much discretion given to it, which is what the Court of Appeal ruled on in August. And a lot of inclusion on watch lists has been, and I've seen this firsthand in work I've done, but also it's been reported in other cases, is quite speculative. So it's a really important question, and it's a hugely problematic area when we start talking about the operational uses of facial recognition. But I'll hand over to Gloria for more.
Indeed, I think there are many ways to discuss this presumption of innocence, and one is the more philosophical idea that these technologies are bringing this shadow of a doubt, imposing this shadow on everybody. It's a bit the Hercule Poirot moment where we know that the criminal is in the room, so we look at all the faces to spot the criminal, but perhaps we are not criminals. There's the more general perception. And then there is a specific issue about the watch list. Indeed, I think this has already popped up in the case law, that the watch list in practice, they just amalgamate all sort of possible reasons why you would be in this watch list, because you are suspected of something, because you are just a person of interest, because you are a vulnerable person and everybody's there, then you are flagged. And you are flagged for which reason? It could be also that it's just you're flagged by mistake, and we know that there are many mistakes, and we know that there are more mistakes depending on the color of your skin and on your gender. So there are indeed tensions with the presumption of innocence, which might not be exactly in the way which then they would trigger the legal protection under this, but it does relate to our notion of presumption of innocence. Just very briefly about Daniel's question about the mask. According to the data protection notice of the frequently asked questions of this Star Alliance biometric system, it depends on the type of mask. So if you have a mask with a lot of little drawings, the system might not identify you properly. In case you don't want to be identified, perhaps you can buy a special mask. Thank you.
Thank you very much, Gloria, for this extra tip. Please, Brian, your closing statement, and then please afterwards directly Xavier. Thank you.
Daniel, and I will be brief. I think there's a lot of research that still needs to be done to make sure we have this technology right. I think the question that came in was quite good there about security standards, and I don't know how reassuring this is for the audience, but the wonderful thing about working in cybersecurity and in IT, if you don't like a particular standard, you can go and pick another one or set up your own one. So yes, there are many different standards out there, and they all do vary. And I think this is where we do have a significant gap between good, strong standards that sets the basics that are required, plus the legal requirements regarding law, judicial laws, and regarding privacy, etc., in that they, by their nature, can't be very specific either. So we have this grey area which companies are trying to develop this software in, and also trying to deploy the software as well. So unfortunately, there's no one standard I can turn around and sort of say, yes, this is the standard that we should be following. But it is important that companies recognize the technical, societal, and legal issues relating to facial recognition software and take appropriate steps to make sure they address those concerns and engage with the right people and the right at all levels in society to ensure that they address those concerns. So that's my brief closing statement. So thank you.
Go now. Can you hear me? Yes. Okay. Yes. In reply to the statements about the fact that there would be more criminals in American cities and states which banned facial recognition technologies, as we discussed, the problem of this technology is that it's not fully accurate, and that there is a risk of bias and false positive, but also false negatives. So I think we cannot say, at the same time, one of the main problems of facial recognition is the lack of accuracy, and at the same time, point to the higher number of criminals allegedly which would be living in the cities and states which bans facial recognition. Now, if we look at the list of states in the US which prohibited facial recognition, I mean, it's a very short list. Out of 50 member states, we're talking only about New Hampshire, California, Oregon, and Washington State. That's all. And when it comes to cities, we're talking about San Francisco, Somerville in Massachusetts, Oakland, California, Berkeley, California as well, Brookline, Northampton, Cambridge, Springfield, East Hampton. Most of them are in Massachusetts, and Portland, Oregon, and Portland, Maine. There are 2 Portlands in the US. So you see, it's not a very long list, and I'm not aware of any data showing that in these cities and that in these 4 American states, there would be more criminals than in other cities and in other states. So I think this is an allegation which is not proven, basically. We don't have any evidence for that, as far as I know.
Thank you so much for this closing statements. Unfortunately, I don't have the time to make a proper closure of this extremely interesting panel. We get a lot of positive feedback via the chat to all of you. I'd only have the possibility to thank all 4 of you, Pete, Gloria, Brian, and Xavier, for your contribution. I'm absolutely sure that in the next Eden conference, we will pick up again this topic. And then maybe we have already some legislation in place that is advanced in regard this new technology. This is not the end of the discussion today, of course, but I'm very grateful for the valuable insight that you gave to us. Sorry also that I have to cut the time here, but I would like to provide now the opportunity to the next panel. These are the masters of the crystal ball. And I would like to ask Jan Ellermann to take over and introduce the next panel. Thank you very much for watching the panel on face recognition technology.